Okay, I think we're live.
Hello, everybody. I'm Aaron Hall, here with Rylan Warner. I think that Jeff Joseph is stuck on a call, but I believe he'll be joining us in the coming minutes. We are going to start, as always, with a few updates, and then we will get right into your questions shortly. So, Rylan, do you want to start with your latest update?
Sure, yeah. So I know that we've talked about temporary protected status a couple times on the most recent Facebook Lives, but since there are 5 countries that now have initial registration period open for them, meaning that if you haven't already had temporary protected status and you're from one of these countries, you can register for the first time as long as you meet the eligibility requirements. And I wanted to go down the dates for those 5 available countries right now, just in case any viewers out there might be eligible for it and not realize it, or they just want the information. So first we have Burma, also known as Myanmar. And so if you have been in the United States since March 11th of this year, and you've had physical presence in the US since May 25th of this year, you can register for TPS until November 21st of this year. So if you have not done so yet and you are eligible, there are, this applies for all the TPS potential applicants, but there are criminal bars, there are other requirements. You're going to want to look up online. I have a blog post that details all this information as well at our website, Immigration Issues, if you have some questions about that. So if you're from Burma, you have until November 21st of this year to register as a first-time registrant. If you're from Somalia, you have until March 17th of 2023. So they're kind of doing a unique registration period. Usually it's much more quickly closed off than that one, but you have until March 17th of 2023. Try to get it in sooner if you really need it. If you are from Syria, you are available for temporary protected status. Hi, Jeff.
Hi.
Nice to see you.
Sorry, I was on a different call. Sorry about that.
Oh, that's totally fine. We got started. I'm just now going through all the available TPS initial registration countries. So Somalia, you have until March 17th of 2023. If you're from Syria, you have until September 15th of this year. If you're from Venezuela, you have until September 5th of this year. And if you are from Yemen, you have until March 3rd of 2023. Like the Somalia one, it's a long registration period, but you should try to get registered earlier than that. For temporary protected status, you get employment authorization, so it's a nice little perk if you don't have that already. And yeah, so if any of you out there listening are from one of those countries and don't already have temporary protected status, or were not even aware of what that program is, we would love to have a consult with you and try to get it all sorted out for you.
Excellent. Thanks, Rylan. I just wanted to give a very quick update about the Attorney General basically vacating another decision by Jeff Sessions. This is the administrative closure decision. So he vacated a case called Castro Tum, which said that immigration judges and the board don't have the authority to administratively close cases. An administrative closure is for cases in immigration court. It's basically a pause on the case while another agency adjudicates some kind of petition, or while they go forward on higher priority cases. So that was used a lot in the past, and then Attorney General Sessions said, no, you can't do that anymore. Well, certain circuit courts disagreed, and so there was an inconsistency around the country, and Attorney General Garland basically vacated Jeff Sessions' decision. What that means practically for people is that lots of people in removal proceedings in immigration court are able to ask for administrative closure either as an act of prosecutorial discretion, or for a lot of people, because they want to consular process, but get their waiver of unlawful presence done while they're here in the country. And administrative closure is a necessary step in that process. So it can for lots of people, it can mean the difference between potentially spending years outside of the country while they process an immigrant visa and spending a matter of only about 2 weeks. So it's very good news for people in removal proceedings. And if you have a question about that or how it could affect your case or somebody you know, feel free to schedule a consultation and we'll look at your case and see how it might affect things.
I have a couple of updates too, if you guys don't mind. Can you hear me?
Yeah.
Oh, great. Okay.
We don't mind.
Make sure that we're good here. Couple things. The first is that Congresswoman Zoe Lofgren from California introduced this week the LIKE Act, the Let Immigrants Kickstart Employment Act. And this is basically a congressional provision to sort of codify the startup visa, the entrepreneur parole rule. This would make it a law rather than just a sort of an executive order. It would create a W visa, and a W visa would be available for individuals who have at least 10% ownership in an interest in a startup entity that has received $250,000 from qualified U.S. investors or $100,000 from government awards or grants, if the individual plays a central and active role in the management and operation of the entity and has the knowledge, skills, or experience to substantially assist the entity with its growth and success. So it's really for investors, entrepreneurs who want to start businesses in the United States. The visa would be good for 3 years, and then there's an additional opportunity to apply for a 3-year extension and 2 further 1-year extension if you can show that you're creating jobs and making certain revenue targets. It also creates a W-2 visa for essential employees of the startup entity. There's numerical limits per entity. And it creates a W-3 visa for spouses and children, and those individuals can apply for employment authorization while they're in the country. So really good option for investors into the country. We'll keep you posted as that makes its way through the House and Senate to see if it becomes a provision. The other thing that I wanted to notify you all about is many of you may be facing huge backlogs around the world, and especially at Ciudad Juarez. If you have been in the immigrant visa queue, there are cases that have been pending for several years now, waiting for interview. We have received reports that people are starting to move again. Immigrant visa interviews are starting to get scheduled, which is obviously really good news. The bad news is that you're not really getting a lot of notice. These people are getting interview notices with literally 2 weeks to come and show up for the interview. So if attorneys and clients that are processing through Ciudad Juarez who've been notified that their case is documentarily qualified need to be prepared for an interview on very short notice. And this includes medical appointments, biometrics, travel arrangements, and time off work. So just be aware that that's happening. We are working through our liaison channels to try and fix this, but we don't want to push back too much because obviously we're really excited that things seem to be moving again. Next thing I wanted to talk about is DACA. As you all know, the district court decision was issued on July 16th, which found DACA, quote, illegal. And as a result, USCIS is not adjudicating cases. So, what is happening is, and they've just updated their frequently asked questions on their website, but essentially what they're doing is any cases that are pending, they're accepting them, they're cashing the fees, but they're not adjudicating. They're just holding them. They're just holding your cases, and they're not adjudicating any collateral benefits either, including work authorization or advanced parole. So, it's problematic because they're taking your funds and you may not have any idea if you're ever going to get an adjudication or if you're ever going to get that money back. On the other hand, if you try and get your money back, you're no longer pending if the case goes well. So, this is really problematic. And I think we may see further litigation on just this issue alone of the government taking your fees and then not doing anything about it. The last thing I wanted to talk about is the H1B lottery. It appears it's been confirmed now that as of yesterday, USCIS conducted a second round of lottery registrations for the H1B cap. What that means is there weren't enough people in the initial round of registrations to meet the cap of 65,000. And so people have been notified, employers and registrants have been notified that there's a second registration. That filing period based on registration selected on July 28th is going to begin on August 2nd and will close on November 3rd. As you know, we have filed a lawsuit challenging the registration process. And, we believe that the lottery is a good thing, that the lottery serves people well, and it prevents people from having to file, all of their cases before they even know that they're selected. However, what is not good is that it also allows one individual to file multiple registrations for multiple employers. And we have challenged that process, and we're hoping that we can get a court to look at that. But the second round makes that case even more urgent now, because people that have registered multiple times obviously have an even greater chance in the second round than they did in the first round. So watch out for the lawsuit. Also, if you registered, contact your employers, because somebody may be getting notification that you are in the queue and ready to be processed. All right, thanks everybody. That's all I had.
Okay, great. Looks like Aaron had to turn off his camera for some reason, so he's back.
No worries.
Back. I had to jump on a quick call.
All right, should we go to questions?
Yeah.
Sounds
Take it
good.
away. Take it away.
Should I put them on the screen for you?
Yeah, let's just go through them. Actually, I think I have to put them on the screen.
Okay.
Okay. So first one is Penn v. Blinken. Status update on Penn v. Blinken. What's going on? There's some movement on the lawsuit. There was a request to add new plaintiffs. Can you explain what's happening on Penn? I can do it if you guys.
Okay.
I'm sorry. I'm happy to. I thought I was trying to unmute myself. So yes, on Penn v. Blinken, there are actually a number of requests for updates, and what I'm seeing is an email was supposed to go out last night through our system to all Penn plaintiffs, and it seems like it might not have made it to you, because this was all explained in the email. So I'm sorry if it didn't, and we will make sure that it gets resent with the update. But let me explain while I have you here. So in the government's latest filing, we noticed that the number of plaintiffs that they reference was not the same number of plaintiffs that we had referenced in our filings. And in doing some investigation, we found that basically a mail merge issue in the program Word had left plaintiffs off the original complaint. So plaintiffs who were always intended to be in the lawsuit were not in the caption in the original complaint. And so the government attorney agreed to help us correct it, basically because they were always intended to be in the case. And so we just had to file that motion with the court. It's an unopposed motion to add plaintiffs, but they're not new plaintiffs. They're the plaintiffs who have been involved from the beginning. All the briefing that's been done stands, and the government they just said that they may file something to say that their previous arguments apply equally to the plaintiffs referenced in the motion to add plaintiffs, but there's going to be no substantive updates. And so the filing won't affect the timeline for the judge's decision. All the briefing is still there, and so we're just waiting on that. And I'm sorry that you didn't get an email, because I'm sure that caused some confusion, and it was supposed to go out, and I'm not sure what happened, but we'll make sure that email goes out as well, so that people who aren't on this live stream all have the same answers. Jeff, did you want to add anything there?
No, that sounds great. I mean, I think, right now we're just in holding pattern on that case, waiting for the briefing. So. But that's really the only other update. If you all have updates of what's going on at the consulates, make sure that you're filling out the spreadsheets. Because that's how we report information back to the U.S. attorney one way or the other. So please make sure that you are filling out those spreadsheets. Let's see. How long will it take for a decision to come out of Go? Why don't we give everybody a Go update? Oops, sorry.
Yeah, I can do that one too. So the how long will it take for a decision and go? Well, we don't know. We know it won't be before tomorrow, because tomorrow is when the government has to submit a filing on standing, and after tomorrow it could come anytime. So could it be next week? Yes. Could it be in a couple weeks? Yes. All we can say is that the urgency of the September 30th deadline is crystal clear to the judge. There's no doubt that he understands it. Beyond that, I can't say exactly when he's going to issue a decision. There's just no way for me to know, and no way for us to control it. I'll address a couple of questions that I saw further down as well, now that I'm talking about Go. Somebody said that we had said that the last hearing would be the final hearing, and why is that not true? It still is true. We don't expect there to be another hearing on the substance of the case. We expect a decision to come down next. We expect that to be the next thing we learn. I thought I saw one other.
I think this is a really good question, Aaron. It's more about sort of just like procedural question. Is it too late to file adjustment now if you're a DB 2021?
That's a really close call. To be clear, and I think that at least the person who submitted the question likely understands this, but just to be clear for everybody else, Go will not cover people's adjustment of status applications. The only defendant in Go is the Department of State, not USCIS. And so if you're applying to adjust and you stay here for longer than September 30th without getting your adjustment application adjudicated, you're not going to be covered for a later adjudication. They're not going to reserve later adjudications for adjustment of status. Is it too late to submit the application? Boy, I don't know. Possibly not. I mean, they should be open to expediting every step of the process, given the deadline. But I don't really trust USCIS, and so it would make me very nervous. I don't know if either of you have thoughts on that.
Just that this is not a case you would do on your own. You should definitely get a lawyer. You definitely want a lawyer helping you make all those expedite requests, because ultimately, I think you end up in federal court on this case. If you have filed the application and paid the fees before the September 30th deadline, and the only reason they're not adjudicating it is because they're just not adjudicating cases or there's delays, then I think you have a good case to go to court, especially when we know that they're just wasting numbers. So I think you really want a lawyer on this, and this is a case, we would take. So, all right, let's see. Lots of pen questions. Okay, so here's one about Ramirez. So this person, Michael, hi Michael, I've seen your emails. I'm thinking about requesting consultation in light of the news that Ramirez plaintiffs are getting interviews, but Manila round 2 K1 cases do not seem to be getting interviews. Do I just need to be more patient, or do you think I need to hire you in a different capacity? I mean, I'll tell you, first, there's not much more we can do that you're not already doing. Right? If you're doing the emails and calling, if you're the US citizen and you're using your congressional liaisons, your congressional representatives, if you are, contacting the people you need to do, that's exactly what we would do. And we don't have any magical powers that are gonna make anything go faster or more quickly. The Milligan round 2 difference in treatment versus Ramirez. Any thoughts on that, Aaron? I think that's a really interesting question. I mean, any thoughts on why that would be the case?
No, I don't know. What are your thoughts?
I don't know, but I think it would maybe be worth pointing out to the U.S. attorney in both cases that, these cases seem to be moving for some reason and these cases don't. And I'm happy to do that today. I do think it's a good point that it doesn't seem to be any, unless there's a reason that they're treating them differently, there should be they're the same kind of case. They shouldn't have any differential treatment. So I think it's a really good point, Michael. Let's see. This one is interesting, and I need more information. This question is, why are we not supporting the EAGLE Act? First of all, I don't recall ever taking a position on the EAGLE Act, but you'd have to be more specific about what provisions you would like me to support I can tell you generally that as a matter of philosophy, I don't support bills that advantage one particular nationality at the expense of the rest of the world. I think that that's not a good immigration policy. On the other hand, I get it that Indians are in a unique position because the quotas have not been changed for 40 years. So in my opinion, it needs a congressional fix, but not one that just says, okay, let's just, give Indians an advantage to the rest of the world's disadvantage. That's not sensible immigration policy as somebody who's done this for 23 years. So if that's the provision you're looking for my support, and that's why I don't support it. I do support, however, long-term immigration reform, including reduction or elimination of the backlogs for all countries across the board. All right, let's see, where else do we go here? Here we go. What if I'm planning to use my tourist visa to adjustment, but I file it as soon as I enter? I know you need to wait 90 days to do so. Also, are you guys able to help go to New Orleans? Thanks. All right, this question is wrought with lots of tricky ethical issues. So who wants to take it?
Not me.
Jeff, can you put it back up on the screen? I just want to make sure I have it
Sure.
right.
Yeah, absolutely.
Yeah. So the bottom line is you cannot enter with a visitor's visa with the intention to adjust status. And if you do so, even if you wait 90 days, the 90 days, that rule that people reference, it's just a guideline. And even if you wait the 90 days, if they find that you have preconceived intent, or that you even worse, if you misrepresent something at the port of entry, then it's going to cause major issues, including a potential ground of inadmissibility that you may or may not even qualify for a waiver for. And so that's kind of the bottom line. Now, the situation is different in cases where somebody enters on a visitor's visa and then circumstances change and they change their mind, or they make new plans. It's a different circumstance. So it's impossible to kind of discuss an individual case in the context of one of these chats, but those are kind of the general issues that we would be looking at.
Okay, great. Let's see. Questions just keep coming in. Patricia, what was the conclusion between you and the government lawyer as of July 26th, time given by the judge? Anyone have an idea of what case she's referring to? Precious, why don't you, if you can put it in the, clarify what case you're referring to in the comments, we'll answer that question. I have a suggestion. Why don't send a new file to the government with date and where we submit our documents to KCC so they don't say we haven't found the documents. Yeah, I mean, if we get to the point where we need to submit more evidence and the government tries to make some argument that KCC is moving, then that would be good evidence to show that, that you all are documentarily qualified as of a certain date. We don't need that evidence now. I mean, as of now, it's pretty much fully briefed, so we really don't need it. But if things come up, we will reach out. Any differences in the probable outcome of go versus good luck?
My speculation here is not really worth your time. I don't know. I really don't know. We're in a little bit of a different posture, as I know that Ronald knows, and that we're seeking a summary judgment where they're at the preliminary injunction phase of their case. But other than that, I don't know. I assume that many, if not all of their plaintiffs have viable legal claims, as do ours. But what that means as far as what Judge Mehta is going to do, I just don't know.
Anything else to add to that, Rylan?
Nope.
All right, so going back to Precious's question, what was the conclusion between us and the government lawyer after the July 26th go hearing regarding the time given by the judge?
What was the conclusion between you and the government lawyer as of July 26th?
We did. I think if you're asking if we had an agreement about how long the time would take for the judge to give a decision. We didn't. There's really, after the hearing and go, there really was no agreement after that. It's just really, we're all just kind of in wait and see now.
The only thing that's happened since the hearing is the judge ordered a filing on standing. He did that in all the DV cases, not just go. And so that was done on our side last Friday, I believe, and theirs is due tomorrow, the government side. And then there's a joint appendix that's due tomorrow, but that's not really substantive. It's just basically organizing records for the court. But beyond that, there's no. I don't know what else you would be referencing. Sorry.
All right, so this is not our litigation, but I'm aware of the litigation. So this is why can't USCIS adjudicate H4 and H4 work authorization along with an H1B when the two applications are filed together concurrently, now that the biometrics is removed. So just kind of give you background on this. Biometrics are now required for I-539s. So if a dependent files an extension of status along with a principal, so in this case, the H1B is the principal and the H4 are the dependents. And if they file a 539 in the past, they've had to take biometrics. And the problem with that is that those biometric delays delay the issuance of not only the 539, but also the work authorization card. So there was a lawsuit about H4 EAD delays. And as a result of that lawsuit, there was a partial settlement, not really a settlement, but the government, in response to the lawsuit, issued a policy basically eliminating the biometrics requirement from those 539s for H's and L's and E's, I believe. Those are the three categories that they eliminated. So you would think eliminating the biometrics would help the delay. They should now just be able to quickly adjudicate the 539 at the same time as the H1B, and that's not happening. And here's the reason, is because, well, first of all, number one is some of the H1Bs you can process under premium processing, the I-129. You cannot premium process an I-539. So naturally, those are going to be processed at different times. But secondly, the H1B processing, the I-129 is with a different unit. And so, the processing times for the 539 unit are different than the I-129. And, it's at that point different. In addition, now, the rules have completely changed. And, it's basically the problem that you get into is you're just talking about two different queues, and the government can't really go and say, Judge, this is how you should tell the government to do it. They can alert the court to what the problem is, but they really can't say, Judge, this is how you tell the court to do it. All they can do is educate the court about how it should be done and hope that the court issues you a decision that is helpful. All right, next one. This is a Go plaintiff, low DV number from Iran. Interview location is Ankara and also a resident of Turkey. Yesterday, Ankara updated website and said they will only do Turkish citizens. So what do we do now?
Yeah, I saw that they updated the website. It's I don't know what basis they think they have to do that, but I know that a number of Go plaintiffs are in the same situation, and it's really frustrating. What can you do now? Well, at this point, I don't actually think I would recommend seeking to transfer it. We're basically into August now. And so I think that now, unless they reverse course, I think we're reliant on Judge Mehta. Judge Mehta, so let's spin it forward. Let's say that Judge Mehta issues the order that we're asking for and orders the adjudication of visa applications. Well, that order, people ask about what's going to happen at this consulate or that consulate, and they all have their particular issues, obviously including Ankara. But the order will force the Department of State to resolve these issues. So the judge isn't going to get into the weeds of you need to open Ankara to non-citizens of Turkey, or you need to do X, Y, or Z for Moscow. Basically, his order would say, get it done. I don't care how. And that would force them to adjudicate our plaintiffs' applications. Or if for some reason that's not possible, then reserve the visas so that they can be adjudicated after September 30th. So what should you do now? I mean, I think you continue to email, contact them, say that that you're ready, that you don't think that it's right that they limit their DV interviews to Turkish citizens. But beyond that, I think you're just waiting on Judge Mehta's decision.
All right. I think that might be all of our questions. Let me see here. Yep, that looks like it's all of our questions. So if you all don't have anything else, then we will check out for this version of Facebook Live, and we'll see you again next week for the updates for next week and what's going on in the world of immigration.
That sounds great. Pen people, we will make sure that email gets out, because I don't know what happened, but we'll get that to you, okay?
Yep, sounds good. Thanks.
All right, thanks all.